Okay, welcome everybody to the Vocational Science of Freedom Saturday night free civics and sovereignty class. And tonight we'll be continuing with Class 6 Docs and Links. And Class 6 is the curriculum of Grand Juries, Power and Use in America. And we've been covering a civil grand jury manual for the last several weeks that came out of, and it's a little bit old. It's a 2099, sorry, 1999 2000 Civil Grand Jury Manual, but it's the only one I have or I could find. This one's particularly for the city and county of San Francisco, California, and we covered the beginning parts of it. So last time we left off at the oath of the grand juror, and I will now show you a comparison. This one being from the civil grand jury, page 13 of the San Francisco Civil Grand Jury, and a oath of grand jurors that I found. I believe it was out of a treatise on grand juries, but the civil grand jury manual says on page 13, the oath taken by civil grand jurors is as follows. I will support the Constitution of the United States and of the state of California, and all laws made in pursuance thereof, and in conformity therewith. Will diligently inquire into, and true presentment make, of governmental matters within this county, subject to investigation by civil grand jury pursuant to law. That's, of course, for the difference where you get the civil grand jury compared to the common law grand jury, or what they call an indictment grand jury. I will keep my own counsel and that of my fellow grand jurors and of the government, and will not, except when required in due course of judicial proceedings, disclose the testimony of any witness examined before the grand jury, nor anything which I or any other grand juror may have said, nor the manner in which I or any other grand juror may have voted on any matter before the grand jury. I will investigate no person, department, or governmental entity through malice, hatred, or ill will, nor leave any uninvestigated through fear, favor, or affection, or for any reward, or for the promise or hope thereof. But in all my presentments I will present the truth, the whole truth, and nothing but the truth, according to the best of my skills and understanding. So help me God. Now, that was the civil grand jury. Like I said, in California, there are two grand juries. There's a civil grand jury, and then there is a what's called an indictment grand jury. Now, neither one of them are over 25 members of the peerage. So they're both de facto, which I covered the difference between a de facto and a de jure grand jury in, I believe it was either class 4 or class 5 for the last, and I've been labeling these grand jury classes as I go through class 1, 2, 3, 4, 5, even though the totality of the subject matter is in what what we call class 6 on the server. I've still just been labeling them in order. And I believe it was either number 4, part 5, where I covered the difference between a de jure and a de facto grand jury. So that's the civil grand jury oath. Now I'll read the one that I posted into the server, into the Vocational Science of Freedom Gilded server. I shall diligently inquire and true indictments and or presentments and or reports make of all governmental and criminal matters, articles, and those things as shall be given or presented, as of all other matters and things as shall come to our own knowledge touching this present service. So right there you see the much more expanded power that this oath automatically gives than the one that is restrictive in its language from the civil grand jury. So to continue from the other oath. And if those charged with prosecution of our presentments and indictments fail to perform their duty to us to prosecute the said indictments and presentments, it shall be our duty to prosecute the same in a court of record to the fullest extent necessary for the security of our realm over which our sovereign power extends. Now, that's an aspect of true power as far as what a grand jury can do. Okay, so, and as I said before, I discussed the security of our realm. I discussed what the realm was in the last class, so I won't rehash that. So, but that was another aspect of an oath that you could use. And here's the thing: there's nothing specific about either one of these oaths that you can't alter. You want to obviously alter it with reason and with proper vocabulary and so on and so forth, of course. But you can take basically whatever oath you feel comfortable taking. There's, as I said before, there's no requirements of a grand jury. They can pretty much do whatever they bloody well want to. And as I stated in the last class, going through the civil grand jury, and just a few pages back, the judge clearly talks about what he can and cannot do with the grand jury, meaning these are all suggestions. In fact, it even says that, I believe, suggestions, suggested procedure, suggested rules of order, right? These are just suggestions, suggested proceedings for organizing, because they can't tell you how to organize. In fact, they can't tell you how to do anything. So just suggestions, as are the suggestion that I gave for a alternative oath. So now to continue, page 14. Charge of the court. The oath of office having been administered, the court then proceeds to charge the jury and give such information as it deems proper or is required by law for the guidance of the jurors. Penal code, such and such, whatnot. Now, there's no penal code and there's no statutes, acts, ordinances, and codes over any properly convened 25-member grand jury of the peerage. None. So again, they would just be suggestions. Conflict of interest code. Again, this code wouldn't apply because obviously it's a code and we're above all that. The city and county has amended its administrative code to adopt. Notice how they adopt everything, like they've adopted you as an abandoned child. Anyway, I digress. A conflict of interest code for members of the civil grand jury, effective July 1st, 1990. Members of the civil grand jury will be required to, quote, ... which meant there was something before that, disclose all investments and business positions in business entities and income from any sources which have done business within the city and county in the previous 2 years, and income from all individuals who are employees of the city and county, and all interests in real property. So they just wanted a whole accounting of every single stupid little infant that went and sat down in their de facto grand jury. If that's not telling, I don't know what is. No one is going to get my information, period. That's called privacy. And that's called none of the government's goddamn business. End of story. Conflict of interest code forms and instructions will be distributed to the members of the grand jury. Questions concerning the code or the forms will be directed to the city's attorney's office. Yeah, well, the city's attorney's office and, like I said, the district attorney's office are the two first offices you're probably going to want to start investigating, meaning bringing indictment against. So, again, this is all about taking your power back. It's not about being subject to their filthy statutes, acts, ordinances, and codes. So, but that's why I'm reading from this particular grand jury, the civil grand jury manual, is to have this ebb and flow, this truth and lies as to what is and what is not. So, the grand jury, its nature and its background. This is a short synopsis of some of the aspects of grand juries. So, and some of this is going to be more pertinent than other parts, and I'm actually slightly interested as to how they're going to spin this. One of the earliest concepts of the grand juries dates back to ancient Greece, where the Athenians used an accusatory body. That's true. Others claim the Saxons initiated the grand jury system. Well, as far as dates are concerned between the Greeks and the Saxons, that would actually be an interesting toss-up. I don't know where that would land. For example, in the years 978 to 1016, one of the Dooms laws stated for each 100 men, 12 shall be named to act as an accusing body. They shall not accuse an innocent man, nor spare a guilty one. Okay, that's more of a petite jury aspect from the Saxon system. The grand jury in its true form, unless you want to take the whole entire court of 100, like the whole entire 100 court, not just the 12 jury members that come from it, but the entire 100 court, as an example of where the grand jury began, I would more along the lines go that route. That's actually, to me, from everything that I know about the 100 court, that was more of what it was, because when William the Conqueror came over in 1066, he disbanded the 100 court. So the origin of the grand jury can also be traced back to the time of the Norman Conquest. 1066, there is evidence that the courts of that time summoned a body of sworn neighbors to present crimes which had come to their knowledge. Right, which is what I was just talking about, which was the 100. But that filthy bastard, William the Conqueror, disbanded them. The members of that accusing jury were selected from small jurisdictions, thus it was natural and indeed expected that the members would present accusations based on their personal knowledge. Okay, that's an interesting point of that too, that, as I said previously in another class, you can walk into any grand jury that's in session, you have access to your own grand jury. Why? Because they're your fellow people. And if you have personal knowledge of a crime, you can take it directly to them. You do not have to go to the district attorney. You do not have to go to any judge or magistrate. You can take it straight to the grand jury and bypass the district attorney. Because the filthy attorneys just want to control everything, but they have absolutely no power. And that includes any judge or magistrate sitting up on the bench, which I mentioned previously when you look at particularly the Virginia Bill of Rights, where it talks about magistrates. It's a good thing to go read. Okay, to continue. Generally, historians agree that the Assize of Clarendon in 1166 was the genesis of our present grand jury system during the reign of Henry II, which was 1154 to 1189, in an effort to regain for the crown the powers usurped by Thomas Becket, Chandler of England. 12 good and lawful men in each village were assembled to reveal the names of those suspected of crimes. It was during the same period that juries were divided into two types, civil and criminal. That I have no knowledge of, so I can't confirm or deny that one, with the development of each influencing the other. Originally, an assize meant a court, session, or assembly. As used today, it refers to the accomplishment or enactments of such groups. Thus, the Assize of Clarendon was the first use of the jury for the purposes of discovery of evidence and the presentation to loyal officials whose persons suspected of crimes. In addition, it reported on other matters relating to the maintenance or order and good government in its district. So, is it a requirement absolutely to have two separate grand juries? No, it is not, because unless you want to, because there's no rules here. So a county could, if they wanted, they could have a civil and indictment grand jury, both of 25 members of the peerage, if they felt like it, because maybe you want to get a lot more business done in the county and you want some of it to be of the running of county government, and you want to clean up your county very quickly with the indictment grand jury at the same time. Perfectly logical, perfectly able to be done. You could totally do that. So to continue with our history lesson here. The oath taken by these jurors was that they shall, quote, do this faithfully, and they will aggrieve no one through enmity, nor deference to anyone through love, and that they conceal those things which they have heard, close quote. By the year 1290, we find that the accusing jury was given the authority to inquire into maintenance of bridges and highways, the defects of jails, and whether the sheriff had kept in jail anyone who should have been brought before the justices. That was an aspect of Magna Carta, and also an aspect of the writ of habeas corpus. But just remember, the Magna Carta was signed in 1215, and notice they don't say anything here about the Magna Carta. Very interesting. Notice they don't say anything here about Article 61 and that there has to be 25 members. Again, also interesting. You see how how attorneys just decide to skip over a bit of history here, like the single most important piece of history, to not tell you what's going on? Yeah, anyway. Le Grand Inquest. Inquest. Does that term sound familiar to anyone who's done their doc set already? Le Grand Inquest, right? Because we at the Vocational Science of Freedom make sure that people do a proof of life and proof of age inquest so that you can claim your estate back from these filthy bastards. But anyway, that's something for another class. Okay. Le Grand Inquest evolved during the reign of Edward III, 1368, when the accusatory jury was increased in number from 12 to 23, with a majority vote necessary to indict one accused of crime. 1368? That's a couple hundred years after Magna Carta, guys. Again, where's the 25 from the Magna Carta? Oops, we just don't talk about it. To continue, the Massachusetts Bay Colony impaneled the first grand jury in 1635 to consider cases of murder, robbery, and wife beating. As early as 1700, the value of the grand jury was recognized in opposing the royalists, obviously, which was the whole thing about the king's admiralty court judges saying and writing back to the king, during the night these colonists disobey the king's laws and destroy his property, and during the day they acquit everyone through their grand juries, meaning there wasn't anything you could do about it. And of course there wasn't. But to continue, these colonial grand juries expressed their independence by refusing to indict leaders of the Stamp Act, as I just mentioned, And a Boston grand jury refused to bring libel charges with other colonies to oppose British taxes and was supported by a Philadelphia grand jury in 1770. Again, same kind of idea as what I was just talking about. They simply refused to indict, which of course any grand jury can do that. The district attorney can jump up and down and scream bloody murder for his filthy crown and his New World Order bullshit, but in the end, the grand jury can tell him to leave the room and never come back. And if he doesn't do that, then the grand jury can order the bailiff or the sheriff to arrest him and throw him in jail for a few days for contempt of the grand jury if he doesn't shut up or stop meddling in, or tampering is the proper term. That'd be grand jury tampering. But to continue, by the end of the colonial period, the grand jury had become an indispensable adjunct of government. Well, it was above all government, as it was in the Magna Carta. They proposed new laws, protested against abuses in government, and wielded tremendous authority in their power to determine who should and should not face trial. Now, notice that earlier part of that little quote. Quote, they proposed new laws? Right. So, the grand jury can get together and do what? They can create law. Now, who would they be proposing it to from a standpoint of a county standpoint? They'd be proposing it to probably the county board, but depending on how your county's set up. Or they could propose it directly to the state legislature as well if they wanted to, if it was a state matter. Or even if it was a county matter, but could be something that could be legislated on the state side. But you want to make sure what you're doing so you're not crossing jurisdictions before you go off the handle willy-nilly with that one. So learn your law, learn what's going on, learn the process correctly before you make some step forward regarding that. But just to bring it up, yeah, you can propose laws to the grand jury. Which, now this is another side note regarding that new law part. Okay, when we're talking about the confirmation of the arbitration awards that we get through arbitrators using the Vocational Science of Freedom status doc set, and particularly the contract that's in it that says if you administer our estates, you willfully enter into being a trustee and agree to be a trustee of our estate, and we're the executor, and you agree to a full accounting of the estate and everything else that it says in the contract. I'm not going to get into it because it's covered in other classes, but in fact, it's covered in Class 4 docs and links. If anybody's curious, you can go back and listen to the Class 4 docs. Class 4 classes, sorry. And if a grand jury showing right there, they propose new laws, okay, what is a confirmation of an arbitration award but to make something a law through a court? Really, that's all it is. So, which a legislature can do by themselves if they wish to, or a judge can confirm an arbitration award, federal or state, depending on which arbitration act you're dealing with, whether it's the Federal Arbitration Act or the UAA, Uniform Arbitration Act. And then the federal one is FAA, Federal Arbitration Act, which is Title IX, U.S. Code. And just simply confirm the award. I don't see any problem with that. I'm going to continue to look into and flesh out that whole idea as far as pulling up and reading as many treatises on grand juries as I can possibly find, and looking into the cross references between what I might be able to locate in the Library of Congress or any other place online for references between grand jury use and binding arbitration. But anyway, so that's something I'm working on. But to continue with our history lesson here. Okay, although originally the Constitution of the United States, that should be the Constitution for the United States of America, but again, whatever, made no provision for a grand jury, the Fifth Amendment ratified in 1791 guaranteed that no person shall be held to answer to a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, maritime admiralty law, or in the militia when in actual service in time of war or public danger, which would be military justice, military courts, courts martial and the like. Public support sustained through the Revolutionary period began to wane in the early 1800s. Adoption of the 14th Amendment see how they make notice of the 14th Amendment, but they totally don't even make any mention of the Magna Carta? Yeah, attorneys. Anyway, adoption of the 14th Amendment in 1868 made it illegal to deprive, quote, deprive any person Now, are you a person? No, you're one of the people. Person is an infant. Go look up Title 1, subsection 8 of the definition of person, and you'll find out that a person is an infant. So, to deprive any infant of life, liberty, or property without due process of law, close quote. As interpreted by some states, this amendment no longer required prosecution of crimes by grand jury indictment or prohibited direct accusation by the prosecutor, meaning information. You see, okay, that's that's hubris right there. That sentence, what they just gave up here, that's pure hubris in your face. They are actually gloating about what they did. You notice that? I'll read that again. See if you catch it. As interpreted by some states, this amendment, the 14th, no longer required prosecution of crimes by grand jury indictment or prohibited direct accusations by the prosecutor of information, meaning the prosecutor could now write his own information. I wonder why. It's because the 14th Amendment is nothing but an amendment to administer public property. Now, in the beginning, it was just all the slaves. The slaves went from private property to public property, period. Sorry for anybody out there that doesn't know that, but that's the truth. And then they contracted all of us white people in later through force, fraud, lies, and coercion to get us to believe that we were a citizen of the United States, which is, if you read the 14th Amendment, you have to be a citizen of the United States in order for this amendment to apply to you and for the jurisdiction of Congress to apply to you, right? So this is not a right. What they're talking about here in the 14th Amendment, this is not a right of one of the people. This is a privilege. This is a privilege of a citizen, of a 14th Amendment citizen under the United States and subject to the jurisdiction thereof. Remember what House said in my, you can go back and listen to the Edward Mandell House quote, where he talks about that we will secure their pledges and give to them benefits and privileges. So, what do citizens of the United States get? They get benefits and privilege. This is the benefit and privilege. The 14th Amendment is a benefit, right? The privilege is to be, or not properly without due process of law, right? But that the privileges they can take away. People, if you're one of the people of one of the republics, then this has nothing to do with you because you're not subject to the jurisdiction of Congress, right? But anyway, that's a that's subject matter probably for another class. So California is one of the states to initiate prosecution by either indictment or preliminary hearing. Now, preliminary hearing is not a word that's completely nasty. It's actually that's an okay thing because what someone is supposed to do, because the grand jury is not ultimately as accessible as all of the judges and magistrates that are out here. And in case anybody doesn't know, mayors are magistrates. Okay, it's just one of the other people that are magistrates, and a justice of the peace, right, magistrate. So what you can do in a preliminary hearing is that one sovereign arrests another sovereign and brings along a witness and says, "Yep, I saw this guy steal this woman's purse," and the magistrate would say, "Did you witness him steal?" "Yes, I did, Your Honor." "Did your madam? Did you witness him steal your?" "Yes, I did." Okay, so then that's a preliminary hearing. It's also called a show cause hearing, where they show cause to create a what's called a warrant of commitment, where they commit the accused to sit in jail unless he pay bail or bond, and then an indictment can come later by giving that information, which was created during the preliminary hearing to put forth before a grand jury. So that's preliminary hearing, and preliminary hearings are actually good things because in every single state that I've ever seen, the penal code for the state, or also called the criminal statutes, sometimes they're called criminal procedure statutes. They have different names in different states, but what I'm getting at is that every single one of them, even statutorily, will say that you must take the arrested directly before the nearest and most accessible magistrate without delay, without question. You want to look up some good cases on that. Heath Boyd out of Texas is a good one, and then Gerstein versus Pugh out of Florida are the two best cases for that, which I've covered in other classes, so I won't go at length into them right now. Okay, to continue. The first California penal codes contain statutes providing for a grand jury to be impaneled quarterly at the same time as the trial jurors were drawn. Early grand juries investigated local prisons, conducted audits of county books, and pursued matters of community interest. As cited, the role of the grand jury in California is unique in that by statutes passed in 1880, the duties included investigation of county government. That's right. You want to control your county? Form your grand jury. Only 7 other states provide for investigation of county government by a grand jury beyond alleged misconduct of public officials. Now, I'm going to go back and reread this here. Only 7 other states provide for investigation. Okay, does that mean that they can stop you as a grand jury from investigating anybody in the county government? No. It's just that they provide for it. They're just like telling you that this is what the state will help you with and go along with it. But you can do it in any state. It doesn't matter because you have the right to a grand jury to conform a grand jury anytime you want to, and that right is absolutely protected and shown in a case called USA versus Williams. And the Supreme Court said flat out, nope, the people can form a grand jury anytime they want to, and there's nothing we can do about it. So, when you have the highest court in their system saying, nope, they can do that whenever they want to, guess what? The states can't stop you from doing it because you could turn around and consider it a federal right. And federal meaning from the standpoint that we, the people, are above both state and federal government. That's what I mean by federal. I don't mean by the use of the word federal that the federal government being over the states and forcing them to somehow have an aspect of uh, grand juries. It just simply means that when we form a grand jury, we're above both both governments, state and federal. So to continue here on page 18, only California and Nevada mandate that grand juries be impaneled annually to function specifically as a watchdog over county government. Oh, that's interesting. I didn't actually know that. It is interesting to note that while the grand jury was abolished in England in 1933, wonder why, at 1933, interesting year, right? When the New World Order pretty much stole everything, both here and over there. In 33, the grand jury was abolished in England. Yeah, food for thought. It has established itself as a component part of our judicial system. As constituted today, the grand jury is part of the judicial branch of government, an arm of the court. Technically, it's the fourth branch of government, so that sentence is absolutely incorrect. It does not have the functions of either the legislative or administrative branches, and it is not a police agency. Well, it can be whatever it wants to be. So think about it. In this book, right there, they just contradicted themselves, right? When it talked about before about bringing forth new law, is that not a legislative process? I believe it is. So you see how attorneys contradict themselves? They're just idiots. Anyway, do what you want within reason and make sure you do it right. It is an inquisitorial and investigative body. Now that part never changes. That's always correct. And is part of the machinery of government. No, it's not. It's above government. It has nothing to do with the machinery of government at all. It is absolutely 100% above all government because it's not controlled. It has there's nothing that can control it. So it's not a part of government. It's above it, having for its object the detection and coercion of flaws in government and the detection of crime among among its citizens. Well, the detection of crime for against everyone, not just citizens but people as well. No one's above the grand jury, which is why Nixon resigned. But anyway, the primary function of the grand jury and the most important reason for its existence is the examination of all aspects of county government. Yes, this includes investigating the disbursement and auditing of the county's monies with the objective of assuring the taxpayers of honest, efficient government. Well, I would say, why don't you go around and find out how each one of these private for-profit corporations is looting you? Like the fact that the district attorney, when you look him up on Dun and Bradstreet, it'll say on Dun and Bradstreet, that's dnb.com, a corporation for credibility of companies, which has been around for a very long time. It'll show you that each district attorney is quote unquote also traded as whatever county. It'll say also traded as, New England County, or also traded as whatever, San Francisco County. That's what the district attorney runs as. He's running a private corporation for profit. In these courts, they're all for profit courts as well. You can track down their Dun and Bradstreet numbers just by setting up a Dun and Bradstreet account. You can do this with if you own a business, you can easily set one up. They'll be happy to open an account for you. And you don't have to pay anything to them. You're just setting yourself up on Dun& Bradstreet so that you have a DUNS number, which is something that a lot of people do. It's no big deal. But then you'll be able to look up everybody else's DUNS number, which is a far more interesting and fun thing to do, because then you can throw the Dun & Bradstreet number of the corporate court that's coming after and attempting to administer your state. You can throw it onto the record as part of the evidence of the record and say, this is a private for-profit court. Where does it have any jurisdiction over I, one of the people? And the answer is they don't. So, but to continue here. Okay, the grand jury has 3 ways to exercise its power. Again, there is no limit to its power. But anyway, we'll see what they have to say. Reports. Written communications of possibly unsatisfactory conditions with recommendations for improvement where no crime is charged. Those are the county reports, and I have no problem. That's a good thing for, for people to do. They should inform the rest of the county what they should be doing and what they shouldn't be doing. Indictments. Number 2. Formal written complaints charging a person with a crime. Right. Accusations, similar to indictments, except that conviction would result in removal from office rather than criminal penalties. Okay, an accusation. Well, an accusation, in case anybody doesn't know this, an accusation is a term under ecclesiastical law. That's canon, folks. An accusation. That's to the ecclesiasticis. That's not common law. You'd bring an action. You'd bring an action, and inside that action, you'd write what's called a declaration. That's how you do it at common law. At equity, you would write a complaint, right? So it's interesting that it says number 2, indictments, formal written complaints. No, 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 no. They're just indictments. It's not a complaint. You never want to use the word complaint when you're functioning as a proper 25-member common law grand jury, because a complaint is an equity procedure, right? As I said, an action at law or an indictment or what's called a declaration, which is what is written inside the action, is what you'd come with an indictment, and then you'd file suit of the action, whatever it is: trespass in the case, aggravated kidnapping, larceny, whatever it is, treason. I don't care. But anyway, so no, those are not the only 3 ways you can do it, because they don't even bring up the fact that you can make a presentment. A grand jury can make a presentment, and a presentment is what you write up and then make and then give to someone who is then going to prosecute the crime. And usually, you give it to the district attorney. But if the district attorney wants to be an idiot and doesn't want to prosecute, guess what? You can get a special prosecutor, or the foreman can do it himself or herself if they know what they're doing. They can prosecute. Doesn't have to be anybody special. Just has to be someone who knows what they're doing. So, and there's plenty of books on that. So anybody can learn. This is not rocket science. So to continue here, page 19. A large portion of the public believes that an individual, particularly a public official, appearing before the grand jury suggests malfeasance or misfeasance. That's absolutely not true. I think you should bring everybody before the grand jury just to have a good talk with them, honestly, and just to remind them who's in charge, honestly, where the power truly lies. It should be clearly understood that it is the constitutional responsibility of the notice they brought that up, of the grand jury to review the conduct of government each year. Exactly. Find out who these people are. Put it in your reports. Joe, who is an assistant district clerk for the county court, seems to be, this and that or the next thing. Tell the next grand jury who these people are and how they act. Are they respectful? Are they not respectful? Are they competent? Give them make them do a performance test. As far as I'm concerned, do whatever you want to clean up your own county government. Totally within your power. So, and this entails having public officials appear before the grand jury for the purpose of providing information to the jury relative to the departments or offices. Exactly. So, like I said, just bring them in. Bring them all in, just to say hi. While it is part of the judicial system, the grand jury is an entirely independent body. Oh, good. Well, I'm glad they finally said that. Yeah, see how they kind of have to correct themselves? Is it part of the judicial system? No, technically it's not. It's really is above everybody. Because clearly, if they can decide to start investigating a sitting president like Nixon, okay, come on. The presiding judge of the Superior Court, the district attorney, the county council, and the state attorney general act as its advisors. Right, advisors. It's all advisory. It's not required. It's not mandatory. It's not law. It's no rules. Right? It's just all advisors. So if your advisor is getting yippity or uppity, slap him across his face, remind him who's in charge. Okay? But cannot prevent the actions of the jury except for legality. Well, there is no legality above the grand jury, so that's a ridiculous sentence. Because of the confidential nature of a grand jury's work, much of it must be conducted in closed sessions. I agree. Members of a grand jury are sworn to secrecy. Fine. Thus assuring all who appear that their complaints will be handled in an entirely confidential manner. That's a good point because you might have people showing up from the district attorney's office or maybe even the governor's office saying, we got a problem over here and I can't tell anybody else, but I know I can tell you guys because you keep it secret. You're going to get that. And that's actually a good thing because people need to have a place to bring the crimes to in secrecy so that someone can take care of it who has the power to take care of it, which is the grand jury. This is how this is always supposed to have been and what it should be now. So just remember that. No one may be present during the sessions of a grand jury except those specified by law. Again, that's of the members of the grand jury, period. I mean, if you want to have the district attorney in there while you might be asking questions to someone else, maybe, but even that, I pretty much keep everybody out. You could keep a bailiff in there if you want. Maybe he can go back and start chattering to everybody else about how you guys are performing and so on and so forth, and you're all good people and whatnot, whatever. But he's sworn to secrecy as well if there's a bailiff in there, or a sheriff's deputy. Same deal. But just as a play to strategy, might not be a bad idea to have one in there. Because again, like I said, they'll probably go talk and be like, no, these guys know what they're doing and they're organized, and bring him inside like maybe a couple weeks after you got everything smoothed out though. So to continue. And the minutes of its meetings may not be inspected by anyone, nor can its records be subpoenaed. Notice that. Minutes of the meetings may not be inspected by anyone, nor can its records be subpoenaed. Guess who gets the records of the last grand jury? The next grand jury. And so on and so on and so on and so forth. How would the grand jury vet its members? However it damn well wants to, Poseidon. Honestly, I would start with the first question: are you a citizen of the United States? You want to weed out most of the problems? That's your first question right there. Are you a citizen of the United States? If they say yes, bye. You don't start off, are you one of the people of California? Because they might say yes to that, but actually be a citizen of the United States. So I would start the other direction. You could even go far as to say, do you have a social security number? Now that you'd probably have a very long-winded period of time to try to find any grand jury members that didn't, but hence the reason why you're here is to start your grand juries from the people that already get vetted here. I mean, I vet everybody. No one gets into this server without me vetting them. So you can start with members of the Vocational Science of Freedom. Yes, I know that roster might be smaller than it needs to be to cover the entire, every county across the entire 50 states at the moment. But nonetheless, that's why you have to recruit people here. You recruit people here for your county grand jury. I will set up your state assemblies here as private rooms that no one else can get into but the people of that state. And then if you want to, beyond that, I can even set up county by county if necessary. I can do this however you want to. But the way Gilded can be used and formatted and implemented for this type of organization is pretty much endless. So there's no limit as to what we can do here. But yeah, simple answer to the question, however you damn well want to. Whatever you feel is good, basically. So you can, yeah, do any kind of questions you want to. I have a personal little fun little psychological test that I do with people that it roots out psychopaths, basically. And there's nothing they can do. They have to answer they answer the questions without knowing what the answers to their questions mean, which is very interesting. And I've always been intrigued by those kinds of tests where you literally you can't lie, like there's nothing you can do to get out of it. I have some tests like that a psychopath cannot get through. You will catch them. So there's all kinds of different things you can do, but there's no limit to what you can do. So that's just a couple suggestions. So have fun with that, however you want to. So okay, so to continue here, Okay, last paragraph. The conduct of criminal investigations and the return of indictments is the smaller part of the grand jury's function in California. Well, right. In some states, all persons accused of felonies must be indicted by a grand jury before being tried. That's also true. So uh, check your state constitution, because it's going to tell you in the state constitution whether that's a requisite or not. This is also true of the federal courts. In any state, the vast majority of criminal cases are presented to the court at a preliminary hearing. Again, like I said, that's true, but then it ends up continuing on to the grand jury, or should continue on to the grand jury if it's a felony. And an aspect of complaints and this misdemeanors and this stuff when it comes to complaints and the charging of our states by saying a person may not do this or a person may not do that or whatever under Roman civil law. None of that's valid under common law. Any grand jury can instantly acquit anyone of any of that idiocy through what's called a writ of attaint, which I'll get into in later grand jury classes. In fact, I'll make it a point to search for, and everybody else should make a point to do this too if you want to do it for your homework, is go search and find everything you can possibly find on the term a writ of attaint, and see if you can't track down some of the colonial courts that would have used them, and get a template. I mean, get an example that we could create a template out of. Try Massachusetts, try Virginia, try um, Maryland, Delaware. See if you can't knock on some of these very old places and see if they don't have and haven't digitized all of these records by now, which I would be surprised if they have. So it'd probably be pretty easy to find. So if we can find a writ of attaint, we can get anybody out of jail, period, as long as you have 25 people. Okay, unlike a trial jury, a grand jury does not pass on the guilt or innocence of the person accused. Again, for the exception of what I just stated, because you can use a writ of attaint to then retry the entire matter in front of the entire 25-member grand jury, and they can just simply choose to acquit right then and there. Because, again, there's nothing higher than the grand jury. Its duty is to decide whether the evidence is such as to warrant charging a person, say charging a person, it should say indicting one of the people with a triable crime, not offense, since such indictment to be acted upon by the courts. The civil grand jury serves as an ombudsman for citizens of the county. The jury may receive and investigate complaints by individuals regarding the actions and performances of county public officials. The jury may receive and investigate complaints by individuals regarding the actions and performances of county public officials. I will leave everyone's homework assignment to go look up what the term ombudsman is. It's an interesting term. Each grand jury is charged with a grave responsibility. The attention of the entire county is centered upon an active grand jury, and its every act is a matter of public interest, right? But not public record because it's secret. Malefactors and unfaithful public servants are uneasy, while honest citizens and conscientious public servants are reassured. Grand jury service calls for diligence, impartiality, courage, and great responsibility. I would agree with all that. Selection for service is one of the highest honors a citizen can receive. One of the people can perform, it should say, and provides an opportunity to be of unequaled value to the community, and I would add to the realm. So with that, we're getting close to an hour here. I would like to set aside a little bit of time instead of going into the next section for anybody who has any questions about what you can do with a grand jury or what else. Any questions you might have had about this particular section of the grand jury. And to flip back, I'll show everybody this was charge of the court. So this was starting on 14. So this was that's the section we just covered. And we covered all the other previous sections in last classes. So if nobody has any questions, then that's where we'll stop for tonight. So we got through the history part. So the next section will be suggested procedures for organizing and rules of court. And I will be sure to interlace this particular section, the organization of the rules of court, with sections from my grand jury manual to broaden the possibilities of what you can do and how you can organize and so on and so forth. But some of these suggested procedures, they're not bad, but we'll cover them next Saturday. So if there's no questions with that, I thank everybody for coming to the Vocational Science of Freedom Saturday night Civics and Sovereignty class. This has been Class 6, Docs and Links, Powers of the Grand Jury. And if you're interested in joining the Gilded server, it is in the links and information for each and every video that is posted online. You can join the Vocational Science of Freedom Gilded server, and up here in the top, you'll want to click apply instead of just follow. So make sure you click apply when you join the Gilded server, and you can take the questionnaire and then join the server and join in our weekly chats and enjoy all of the other things that we post about in the Vocational Science of Freedom Gilded server. And with that, I will turn off the recording. We can talk amongst ourselves.